All rise. The appeal in the name of Trevor William Moore and the mother and 3 Adler and
Yes, Mr. Matt. May it please my lord and my ladies, I appear together with my learned friend Mr. Dos Santos for the appellant. Learned friend Mr. Thomas represents the respondents. My lord and my ladies, by way of introduction, the court will be aware that this is an appeal against refusal on the 12th of November 2021 by Mr. Justice Kerr to grant permission to apply, which was sought by a claim form sealed on the 13th of November 2020 under Part 81 of the CPR for an order of committal against their respondents for their contempt of court. That's the 2 respondents. As the court will be aware, the contempt claim arises from applications made by the respondents to a circuit judge sitting at the Crown Court at Chelmsford for search and seizure warrants to be executed at the appellant's home and the first appellant's registered business address. I should make it clear that both the applicants are in court today. The warrant application form contained clearly worded, detailed declarations requiring full and frank disclosure to be made when making warrant applications. We respectfully will submit that the respondents demonstrably both withheld material information from the court and secondly, at one of the hearings, in answer to direct questions by the circuit judge at the hearing of the application at the Crown Court at Chelmsford on the 9th of April 2019, the second respondent provided information which was, we respectfully submit, demonstrably inaccurate and in which she can have had no reasonably held honest belief in its truth. The warrants were challenged, as the court will be aware, in judicial review proceedings, and it was conceded on behalf of the respondents that the warrants were unlawful. We respectfully submit that the circuit judge was wholly misled and that the respondents' conduct constituted a contempt of court. I will turn in due course to the particulars of contempt when dealing with the merits of the appeal. Can I make it clear, so that the court understand the way I propose to go with my submissions, that there are 2 main parts to these submissions. The first relates to the test for permission, and that will also deal with questions which the court has raised when permission to appeal was granted on the 18th of May 2022 by the Right Honourable Lord Justice Stuart Smith. In granting permission, I shall take the court to that. And the second aspect of the submissions relates to the merits of the appeal, and we respectfully submit, in reminding the court, of course, that when we turn to the merits, it is an application for permission which we respectfully submit was well-founded, and of course remind the court that we're not asking this court to determine at this stage the full merits of the appeal. So can I respectfully start with the particulars of contempt, just to remind the court where they are, which are to be found in the permission bundle. I trust the court has hopefully 4 bundles. It should be a core bundle, a permission bundle, and 2 authorities bundles. Yes, I'm grateful, my lord. So can I ask you please to start, just to assist where we are at the in the permission bundle at tab 8.
No, we don't have tabs.
Oh, I'm sorry,
we do have pages.
I'm grateful. So I think you'll find it at pages 13 to 20. Just to remind the court, I don't need to go at length to it now, just for convenience, so you can see how it's set out at those pages, 13 to 20. I'm not trying to skip around too much, but I want to deal with the first aspect of the submissions shortly. But can I, in so doing, ask the court now to look just at the core bundle at page 55, because that deals with the parameters of today's application.
Can before we do that,
Yes.
Can you just tell us under which provision of the rules permission was sought? Is it 8135B?
Yes, my lord, I can help you with that. I was going to come to that very shortly.
Okay.
If you just give me a matter of minutes, I'll deal with development. It is right that, of course, Part 81 has changed in its format.
Yes.
That may have resulted in a level of confusion. So I can just briefly take my lord and my ladies to the page 55, which was the when permission to appeal was granted on the 18th of May 2022. Your learned a colleague, the Right Honourable Lord Justice Stuart Smith, said this in relation to reasons 2 and 3. When permission to appeal is granted at 2, in my judgment, an appeal has real prospects of success. That is sufficient for my decision. But also, importantly, at 3, I also consider that it may be beneficial for the Court of Appeal to give guidance, A, on the test for the giving of permission in such cases, i.e. how high the threshold should be set, and B, on whether there are particular features to be borne in mind in a case alleging contempt of court by a police officer in seeking and obtaining a warrant, C, in relation to paragraphs 24 to 28, which we shall go to the case of Berry Pilling. And so that is why we've broken up our submissions into 2 ways to hopefully assist the court. So the first part of this application engages those issues in relation to the aspects set out at paragraph 3 of that order. Before I turn substantively to those questions, there really is a procedural issue that I think my lord has identified. After the present claim was filed, which was after the amendments to Part 81 entered into force, the matter was transferred to the administrative court. And if we go to the permission bundle at page 8, we can see there that by a decision dated the 21st of September 2021, which was made on the papers by Sir Ross Cranston, City as a High Court judge, the application for permission to bring contempt proceedings was refused. And you'll see reference then, we'll come back to it. It's important to look at those reasons, and indeed it's a point that my learned friend will rely upon the behalf of the respondents, set out at first reasons. The claimants must establish a strong prima facie case that the defendants made a false statement the defendants knew at the time it was false, relying upon the Superbikes case. Just so that the court can understand where we're going to go, perhaps paragraph 4 is interesting too. While if true, dealing with the evidence, this evidence may evidence carelessness, it does not, in my view, establish a strong prima facie case. And those words are going to be important as we will seek to argue of the defendants deliberately seeking to mislead the judge. The high threshold for granting permission is not met. And then there's an overriding objective point that I don't think is really so material in terms of what happened afterwards before Mr Justice Kerr. So the appellants applied to set aside that decision, and it was considered by him. And the first procedural issue which needs to be raised for the court's consideration is whether or not the matter should indeed have been transferred to the administrative court in the first place, because before the amendments to Part 81 in November 2020, Part 81.13 sub 2, which we don't have, we were conscious not to overburden the court into the documents, but I can provide it for you to assist, that Part 81.13.2 then stated, in applications for contempt not arising within existing proceedings, and says this, that where contempt of court is committed otherwise than in connection with any proceedings, the application for permission may be made only to the administrative court. So that was how it was under old 81.13.2.
Sorry, can you just read the provision again?
Yes, of course. We probably have hard copies. Would it be of assistance to provide the old?
If you've got them, then why not?
I'm sure we can. we'll have that. My
Yes.
learned junior will provide. But can I read out the wording of
Yes, please.
how 81.13.2 used to say? Where contempt of court is committed, otherwise than in connection with any proceedings, the application for permission may be made only to the administrative court. So that was the position until the amendment in November 2020. I think copies are being provided now. The amendment, so that's the old law. The amendment to Part 81, and we can see that in the authorities bundle at page 4, right at the beginning of the first set of the authorities bundle. So it's under the section of Part 81 as the law is now. And do you have page 4?
Yes.
And you can see there the amendment to Part 81 provides at 81.3 sub 8. If permission is needed and the application does not relate to existing court proceedings or relates to criminal or county court proceedings or to proceedings in the civil division of the Court of Appeal, the question of permission shall be determined by a single judge of the Queen's Bench Division, of course now King's Bench Division. If permission is granted, the contempt application shall be determined by a single judge of that division or a divisional court. So that appears to be how it's determined, a single judge of the now King's Bench Division under the amendment to Part 81. And it is our submission that the matter should never have been transferred to the administrative court in the first place. So that's the first observation that we make. Of course, we recognise we are where we are, and but it is.
Sorry, does it matter? I mean, Sir Ross Cranston. If you looked at Sir Ross Cranston's order at page 8,
Yes.
if you crossed out the word administrative court at the top, there wouldn't be anything wrong with it, would there?
No, my lord. It's a small point. We do think a little error crept in, but
I don't know whether there might be a separate point as to whether should have gone straight to an oral hearing. I don't know. Is that a procedural complaint you make, or is it simply a question of which hat Sir Ross was wearing?
Again, it may not matter too much, but we respectfully submit that it should have gone straight to an oral hearing and should not have been determined on the papers. So, although it's historical, but obviously this court want to ensure that a full historical chronology is accurately set out, that both those aspects were open to question. Secondly, the first decision, so we say importantly that shouldn't have been transferred to the administrative court, and we know the decision was made on the papers, and really tying in my lord's point, not only should that have not happened, it is of some interest and potentially of significance that wasn't as a consequence of any request or application by either of the parties, and indeed, for what it's worth, the views of the parties were not sought. This was a decision taken without application from either side. Notwithstanding that there is no express provision providing for such an approach, we say in Part 81, and we say that the decision did not state which procedural rule or power was being used to make that decision on the papers without a hearing, because we know the matter was not either a judicial review or a statutory appeal with a paper filter. We acknowledge, and it's important that we don't get sidetracked into unnecessary issues, that the court has a power to make that decision of its own initiative without hearing the parties or giving them an opportunity to make representations pursuant to CPR parts 3, 3, 1 and 4. So my lord is right. This is a procedural point that we don't quite follow. It's not clear from how Sir Ross Cranston determined it, what power is exercising, but there undoubtedly is such a power that we accept exists, although procedurally we have difficulty in following how it came about.
I don't know whether it is the usual practice, rightly or wrongly, in the admin court these days for an application for permission to bring contempt proceedings to be considered by a judge on the papers as opposed to going straight to an oral hearing.
Well, given the significance of committal proceedings, one can readily see, both ways, frankly, one can readily see why it would have been probably, I say respectfully, might have been safer or wiser to have had the hearings, particularly as no party made an application, to have this argued orally. But we accept, as I've indicated, there is, of course, an inherent power to the court. But the difficulty we have, what we're faced with, and the court is now facing, is the paper permission refusal application, and that paper permission refusal doesn't explicitly set out the right to apply to set aside the decision, which would be required. I don't think I need to take the court to this, to CPR 3.35b, and looks much closer, and one of course readily understands that from the administrative court usual functions, a paper decision in a judicial review claim. It does have that feel of being considered on the papers in that way. The assume and accept that the applicants determine that the power was used in that way and applied under CPR 3.35a to set aside the decision and to seek a hearing of the application. So that's how it got to Mr Justice Kerr. And so the appellants submit, the applicants submit, that these applications, absent agreement of the parties for the matter to be dealt with on the papers, should, because of their very nature and the absence of a paper filter, be ordinarily considered at an oral hearing under Part 81. So we respectfully submit it may be of assistance to consider that point as far as guidance in the future in this type of application, because of the inherent apparent confusion which was created by the way in which this application was initially considered. We make it clear we do not make any complaint about it. We advance it to illustrate the potential procedural confusion which can arise where an application for permission to bring contempt proceedings are being contemplated, so that the court, if it wishes, may address these issues when giving guidance to assist parties in the future. Can I now, having dealt with that preliminary point, which as I say, doesn't go to the merits, but in my respect, it is a curious feature, turn to the two questions posed by the court. The first question is the test for giving permission, and we need to turn, of course, to the judgment in Berry Pilling, which is specifically cited by Lord Justice Stuart Smith. So can we turn to the authorities bundle for reference? I will come back to this, but it's at page, it's in the second authorities bundle, starting at page 236, Berry Pilling case.
It's probably piling, isn't it?
I'm sorry?
It's probably piling.
It certainly is.
It's a construction.
It's a single L. My lord's absolutely right. Very piling. I'm grateful my lord pointed out the first time, so I didn't make the error 6 or 7 times. So the relevant paragraphs are at page 244 under the section of the law, and there's reference which we shall go to Malga, which I shall come to in a moment. But my lord and my ladies will see that the contempt of court is dealt with generically at paragraph 24. Paragraph 25 deals with the Malga case, which we shall turn to shortly. Paragraph 26, the Edward Neild case. Paragraph 27 talks about the issue of recklessness in a criminal law context. And importantly, at the end of 27, last sentence, it can, however, be a fine line between mere carelessness or negligence and recklessness in the making of a statement. And then one recognises in the criminal courts a very important distinction between carelessness or negligence or even gross negligence and recklessness. There are, of course, a small number of criminal offences that can be committed by gross negligence, most famously, of course, manslaughter, but generally that will be insufficient in criminal law to found a successful prosecution. And then paragraph 28, which is perhaps the most important, because this is what we will seek into court to consider. On balance, I conclude it can be contempt of court for a witness to make a statement supported by a statement of truth recklessly. That is to say, saying something which can be proved beyond reasonable doubt that he or she, and it's important to realise, of course, that is the criminal test, which is relevant in the context of contempt, that he or she consciously had no idea whether it was right or wrong. This is supported by the wording of CPR, Part 32.14, and by the Vice-Chancellor in Malgar, referring back to paragraph 25, when he said that CPR 32.14 did not introduce a new category of contempt. It is not undermined by the Nield case, which is not concerned with whether a reckless statement would amount to contempt. And then this. Recklessness is a concept which judges can address, as they do in a criminal context. Logic also suggests that the person who represents as true something which he or she consciously does not know whether it is true or not is consciously misleading the court, and that should be considered as contemptuous. So that's a paragraph that we would seek to rely upon and develop. Under the regime in Part 81, first of all, we know that CPI 81 does not provide guidance expressly on the test for granting permission. We know, and it's noteworthy, that permission is not always required for contempt proceedings. So under Part 81.3.5a, we can briefly perhaps just go there for confirmation. It's in the authorities bundle at the beginning at page 4. Um, 81.3.5a, permission is required except in relation to existing High Court or County Court proceedings. Next, we submit that the main authority on the grant of permission is the case of Tinkler and another against Elliott.
Now, while we're on 81.3, you said you were going to answer the question about which is the paragraph under which the application is made.
Yes. 81.3.
Is it 81.3?
81, I think it was 3.3.
So it's under 3, it's not in relation to High Court, County Court
Yes.
proceedings.
3, so not in relation to the County Court proceedings. So can I take you on page 4 to 81.3. 3. A contempt application in relation to alleged interference with the due administration of justice otherwise than in existence High Court or County Court proceedings is made by an application to the High Court under Part 8. And then we've got what flows from that is subparagraph 4, 5, 6, and 7. And then we have, so therefore, that's the, and then at 8, if permission is needed, the application does not relate to existing court proceedings or relates to criminal or county court proceedings or proceedings in the civil division of the Court of Appeal, the question of permission shall be determined as, and we've gone through that already.
But is the basis of the application, is the alleged contempt knowingly making a false statement or interference with the due administration of justice?
I think it, arguably under both. The question is whether knowingly make a false statement, whether the concept of recklessness can properly be considered in relation to knowingly made a false statement. But if not, and that will be our primary submission, if not, it is interference with the due administration of justice if such a statement, even if the court were not satisfied it was knowingly, intentionally made, if made recklessly, satisfying the test that we respectfully submit the authorities back and support, it can nonetheless be caught under 5A. Right. The difficulty, well, the authorities seem to, we respectfully submit, I should take the courts to suggest that it goes, then, as far as B is concerned, goes beyond knowingly. The question of knowledge in a context of recklessness is a fine, an important issue to determine. That there is some judicial guidance in relation to that, but that is an important question which we respectfully submit. In other words, if there was recklessness to the extent we respectfully submit that this is borne out in this case, that will come under the contempt proceedings set out under 5B. So that would be our primary submission. But we say, in any event, if it is not even quite, if it falls slightly short of knowing, it nonetheless is and should be caught under B. If the court wants, we can go back to how we pleaded it in the initial contempt application, which we pleaded both for that reason.
Yes. Well, you're going to come to that. Speaking for myself, I think it's very difficult to interpret the rules as in such a way that if you fail in persuading us that this should have come within 3.5b, that nevertheless 3.5a means that recklessly making a false statement, if it doesn't fall within 5b, is covered anyway because it's interference with the administration of justice. Lots of things could be said to interfere with the administration of justice. But if let's say, mere carelessness in making a statement may well interfere with the administration of justice, but it's clearly not within 81.
On carelessness, we of course would accept that. The difficulty with is, as we've already seen, and we're going to see hopefully more with the authorities, is that recklessness is distinguishable from carelessness, and comes much closer, we respectfully submit, to intentional or knowingly. Sorry, can I please take the court to the case of Tinkler and Elliott? We respectfully submit that is the main authority on the grant of permission, not the authority my learned friend relies upon, the KJM superbikes, although we will, of course, take the court to that. So can I ask you, please, to look at that authority, Tinkler, which is at 354. We're going to come to that in a little more detail, but can I take the court, please, to the section that deals with the correct legal approach, which starts at paragraph 44 at page 365.
Can we just look at the nature of the case? It was a case in which Judge Pelling had given permission to Mr. Elliott to bring committal proceedings in respect of what?
The salient facts can be seen starting at page 355. it probably would it be of a, I mean, I'm very happy to read it, but the
I just wanted in a few lines what the alleged contempt was.
So that can be found. That can be found at that can be found at page 359, which relates to paragraph 18. Mr. Elliott did not comply with various injunctions of Gwynedd. As a result, there were 3 contempt applications brought against him by the Stobart parties, and that arose out of what happened, and that's at paragraph 17, in relation to injunctions and the alleged defamatory statements, injunctions being obtained, and it was claimed that he had breached the terms of those injunctions, as set out in paragraph 17. I'm happy to go. I think factually it's very different from the present case, but I perfectly accept that it is not a police case or anything similar to that.
Alleged contempt by breach of an injunction. Right, and the upshot of the appeal was, I think they set aside, this court set aside Judge Pelling's decision.
Yes.
Right. Okay, paragraph 44.
Thank you, my lord. The correct legal approach to the termination application of permission to bring committal proceedings was not in dispute on this appeal. The judge correctly summarised the relevant and well-known principles in paragraph 23 of his judgment. I don't think we need to go to every aspect of that, but if you look at sub 3, 23.3 at the bottom of 365, a statement made by someone who effectively does not care whether it is true or false is liable as if that person knew what was being said was false, and there's a reference there to Berry Piling. But careless will not be sufficient, and again, reference to the same authority. So, taking my lord's point, there is an important difference identified here between someone, if not knowing, not caring whether it's just true or false, is as liable as if that person knew. So that's our respectful submission, that has the sound of recklessness about it, distinguishable with carelessness. At 4, and this is something my learned friend relies upon, and we shall seek to try and understand and assist the court in relation to what this test is, permission should not be granted unless a strong prima facie case has been showed against the alleged contemnor, and that's the Malgar case that my learned friend relies upon, and there's a reference there, and of course, Berry Piling, and we shall come to that, I hope, shortly. And then there's a reference I don't think we need to go to in relation to proportionality. Then there's a section, a subparagraph 7, to do with the public interest, and I shall come back to the public interest in due course when one looks at Mr Justice Kerr's decision in that regard. And then at 8, in determining permission applications, care should be taken to avoid prejudice in the outcome of the application if permission is to be given by avoiding saying more about the merits of the complaint than is necessary, and that's the Superbikes case. Important, of course, to note that we respectfully submit this is a permission application. This is not a determining, obviously, ultimately, of whether contempt is borne out.
Well, on that last point, surely, if you grant permission, you have to be very careful about what you say. If you refuse permission, you have to give reasons as to why there's no case. But it's a bit like letting a case go to the jury. You have to be very careful not to say this is a really strong case.
Yes.
But if you say there's no case, then
you have to explain it. Exactly. And of course, that unless subject to appeal, that will determine the issue. Absolutely. My lord and my ladies, we want to take the court in due course to the strong prima facie case point, because that is, of course, of a considerable significance. We know that in this case, as we can see, that KJM is cited and applied, but we respectfully submit that the respondent's reliance upon the KJM case is misplaced. Can I take you to a small number of authorities in that regard? First of all, we would like the court to look at the case of Walton and Kirk. Now that's at page 102 of the authorities bundle. And the relevant section in that case is page 106. I'm sorry, I know I'm jumping about with the authorities a little bit. Paragraph 14 at 2.4, page 106. In the light of the authorities noted above, I summarise the relevant principles as follows. A. The applicant must prove each of the three elements of the contempt beyond a reasonable doubt. Given the quasi-criminal nature of contempt proceedings, any genuine doubt must be resolved in the respondent's favour. So, of course, we accept that it's quasi-criminal in nature. B. The three elements are A. 1. The falsity of the statement. 2. The false statement has or would have interfered with the course of justice. 3. When the false statement was made, the maker had no honest belief in the truth of the statement. C. Exaggeration of a claim is not without more automatic proof of contempt of court. What may matter is the degree of exaggeration. The greater the exaggeration, the less likely it is that the maker had an honest belief in the statement verified by the statement of truth, and or the circumstances in which any exaggeration is made. The statement to an examining doctor may forgivably focus on the worst aspects of the maker's physical condition, while it may be less easy to dismiss criticism of a similar statement made when the maker has been repeatedly asked to specify variations in his or her physical conditions and chosen only to give one side the worst of the story. And that may be of some assistance to the court in the present case. We say that summary is consistent with the decision in Berry Piling, and the passage that I've quoted to you before at paragraph 28. I don't think we need to go back for present purposes, but that's at, just for your note, at page 246 in the authorities bundle. And there's reference in that case to the Malga case, and indeed it's a point my learned friend relies upon. So I think we should go to two cases that may assist in relation to understanding the important question of strong prima facie case. So can I ask you first of all, please, to go to Malga, which is the relevant passage is at page 396. Sorry, I'm wrong. Misquote. Page 55. Sorry, the authorities bundle. It's paragraph 396. Case starts at page 52. So at page 55, the Vice-Chancellor says, in the middle, towards the top of the page, dealing with the general law in a particular area, and at about line 10 or 11, on one view, it must be shown the individual who is being prosecuted for this species of contempt intended to interfere with the course of justice. The other view is that it must be shown that the individual intended to do the acts in question and the acts interfere with the course of justice. and no issue with that. But if you look towards the bottom, well, there's a reference there to the difficulty lies in knowing quite what mental state on the part of the accused has to be shown. But I would think that it must in every case be shown the individual knew that what he was saying was false and that his false statement was likely to interfere with the course of justice. And then at the bottom of that page, I repeat that these are not proceedings brought for the furtherance of private interests. They are brought in the public interest and are in some respects like criminal proceedings. Nevertheless, they are civil proceedings. They are civil proceedings to which the overriding objective under CPR Rule 1 is therefore applicable. And interestingly, at page 59...
Well, before we leave this page of Malgar, are you saying that the last sentence of the first long paragraph on 396 is wrong?
We are saying, not that it's wrong, but one has to look at the context of what was decided in the Tinkler case to understand the nuance of knowledge. In other words, although it says the individual knew what he was saying was false and his false statement was likely to interfere with the course of justice, the question of what constitutes knowledge is not the same, is not to be narrowly construed as meaning intention, active intention alone. In other words, we don't challenge that in the majority of cases, one would recognise an intentionality behind it, but we do not respectfully submit, and we say those authorities to support the proposition that it goes beyond actual knowledge and it's to be properly construed to constitute recklessness in the sense that we've already taken you to in the Tinkler case. Can I, because it's important that we deal with my learned friend's contentions, also take you to one other case. So the other case that I wish you to look at is the Keisha case, which is the next Kabushiki case, which starts at page 61. And would ask the court, please, because there's a lot of reference to the Malga case, starting at page 64. Can I take you, please, to paragraphs 22 and 23 at page 65. It seems to me this is the case which I have indicated should, as to the particular false statements I identified, go forward to trial. I have in mind particularly what is said in Malga's case in the judgment of the Vice-Chancellor at page 400, where it is plain that the court must be astute not to allow tenuous or argumentative applications to commit to go forward. 23. I am satisfied that the allegations here are not tenuous, though whether they amount to contempt, of course, is not a matter for me. In those circumstances, I propose to allow the application to the extent I have indicated accordingly. What we respectfully submit is that one was looking at strong prima facie case. One is looking for a distinction between tenuous, argumentative type applications, and if they're not tenuous, then that amounts to a strong prima facie case. In other words, there's nothing additional in relation to strong prima facie case, provided they surmount the threshold test of not being tenuous or argumentative. Because prima facie case, on the face of it, as the courts will be familiar, is a relatively low threshold. And there's a potential tension to be determined between what is strong and what is prima facie, that they, to some extent, are not obvious bedfellows, if I can use that expression. And that what the courts are contemplating in this regard is strong means not tenuous, argumentative, or doesn't meet that, if you like, that threshold. And once it is not tenuous or argumentative on that threshold, respectfully submit that meets the prima facie test, which we respectfully submit is exactly what the court had in mind. And we do need to go back now to paragraph 28 of the Tinkler case. So can I just ask the court for one more time to return to page 246 with that in mind?
Is there any authority other than the one you just showed us, paragraphs 22 and 23 of Mr Justice Pumphrey's judgment, to suggest that strong prima facie case means a case which is not merely tenuous or argumentative?
We couldn't find any further assistance in relation to what strong means beyond not being tenuous or argumentative.
Well, it means something, doesn't it? There's a difference between a prima facie case and a strong prima facie case.
Well, that's why I think the court's what we're trying to wrestle with. We are trying to help the court by trying to understand what strong adds to prima facie. And as I respectfully submit, strong prima facie could, on one view, be a higher threshold than prima facie. But on the other hand, prima facie of itself, in many legal contexts, is understood to be, I would say, a low threshold, but not the highest of threshold, because, of course, the ultimate question is not being determined by the court at permission stage. So what we are trying to do is suggest what strong means is not tenuous or argumentative. We certainly couldn't find any authority, my learned friend cites one either, that give any further assistance in relation to what, if anything, strong adds to prima facie. The closest the closest we can find is really Berry piling. Well, I was going to take you to paragraph 28. It might be helpful if we look at paragraph 30, which I think gives a little bit of assistance to my Lord's question. As I say, I want to come back to 28, but if you look at paragraph 30, there's a little bit of assistance there to my Lord's question.
So sorry, can you just give me the page again?
Of course, page 246, my Lord, at the bottom.
I'm not sure it adds a great deal more, does it? It just repeats it.
It doesn't add a great deal more, my lady. If anything, A really supports the observation which has already been made about what, if anything, is added to a prima facie case by saying that A, it is not enough for there to be merely a prima facie case, it must be a strong case. My lady, I agree. We're straining to assist, but there really isn't very clear guidance on precisely what that strong prima facie
it sort of connotes more than.
Sorry?
It connotes more than prima facie, doesn't it?
Something yes, but not clear how much more. Yeah. It may be it's a little more. One doesn't know. Yeah. What we do say is this, that it can't be much more than prima facie because one recognises in the criminal context, and I could go, I'm not sure the court's much assisted, but we looked at other types of jurisdiction to see if we could get anything from that. And we thought about the Galbraith plus test in the inquest scenario, which I'm happy to take the court to. Of course, it's not exactly this situation, but we respectfully submit it can't be higher than the criminal test in relation to prima facie because although this is quasi-criminal, it is actually a civil question to be determined. So,
well, no, surely that's wrong. I mean, contempt is quasi-criminal for a number of reasons, including the fact that you have to prove beyond reasonable doubt that the contempt was committed.
Yes, at the full hearing, of course.
And surely the Galbraith analogy can't possibly be a question of a strong prima facie case.
My lord, I'm sure it was me. I was trying to deal with the Galbraith test, of course, is a criminal test.
Yeah.
The Galbraith plus test is a different standard that's applied in an inquest scenario, which I can assist the court with, of course. But, my lord, of course, ultimately, no one questions that contempt proceedings are important for many reasons, for both sides. That, rightly, and we don't challenge this, there needs to be a criminal standard of proof before a contempt is successfully established against an alleged contempt. Now, undoubtedly, because the implications are substantial, including, of course, the possibility of a custodial sentence. But, importantly, that in our respectful submission, that is not for the determination in relation to whether permission is granted. In other words, the strong prima facie test should not be thinking to apply the criminal standard in relation, at that stage, in relation to permission. Of course, ultimately, if permission is granted, undoubtedly and correctly, there is a high standard of proof required. But we respectfully submit that there can be a danger of confusion in relation to whether permission is granted on that test and thinking about the criminal standard for the purposes of establishing ultimately the actual contempt. That's how we put it. So can I go back to paragraph 28, because I think having looked a little bit at the authority, the context may be more understood now at paragraph 28. On balance, I conclude it can be contempt of court. Of course, the material word is can here, applying again in relation to permission, for a witness to make a statement supported by a statement of truth recklessly, that is to say, saying something which it can be proved beyond reasonable doubt, and again taking my lord's point that it's a criminal standard, that he or she consciously had no idea whether it was right or wrong. Now, having no idea whether something is right or wrong is not the same as intention. Intention, you know it is wrong.
Yes, I'm slightly struggling with how you consciously have no idea.
Sometimes people will choose to, as we say happened in this case, answer questions where the clear inference was they should be saying, I don't know. And they positive scenario of certainty about something of which they actually don't have any knowledge. And therefore, that is beyond simply getting it wrong. This is something which is relied upon as being authoritative because of the response that's given. I'm trying to think of an analogy in a different scenario. Yeah. I don't know how much this helps.
I was really questioning the concept of consciously having no idea. I mean, either you don't know about it or you do, and if you do know about it, then you know about it.
Yes, okay.
You know
This may not be a perfect analogy, my lady. I'm obviously conscious of the intellectual issue that's at stake here. If I was asked what happened in the court below and answered, I had no idea whatever, one way or the other, didn't seek the, no doubt, helpful advice of a learned junior or my instructing solicitor, but volunteered to the court something which I had no idea was true or not, but because of the status as me as counsel, one would hope that the court would accept as given honestly and authoritatively. That would be something which, if really had no idea at all what happened below and just volunteered firmly something that had happened, that might be the sort of scenario where there's a conscious failure to check a position and to assert something which you know isn't true. Or you can't know it isn't true, but you have no basis to know whether it's true or not. I think that, I'm not sure it's perfect, but it gives you some idea that there's something contemplated, I think, in this case, when, paragraph 28, when the court, Mr Justice Aikenhead was talking about recklessness. And that does appear to have some similarities with a criminal test in relation to recklessness. And of course, we don't need to to descend into the criminal arena, but of course there was a time in which there were two sorts of recklessness that existed in criminal law, Caldwell and Cunningham recklessnesses, which were distinguishable. Caldwell recklessness was culpable criminally, and Cunningham recklessness was not. So the courts have had to wrestle with this question of recklessness in many different jurisdictions in many ways. I'm going to, Malone Julie reminds me that we will go to what the second respondent said
Yes, no, I understand
to
that.
the judge.
This was simply a...
Yeah, but we say what the second respondent did to the judge then comes within this type of recklessness,
Yes.
as defined by Mr Justice Aikenhead.
So putting it shortly, because one has read the judgment.
Yes, of course, my lady.
He says she was out of her depth. So in that context, you are saying she makes statements where in fact she really doesn't know what she's talking about. That's a very simplistic way to put it, but is that the essence of it?
It is, but it's not, it's something where she shouldn't. It's more than just making a mistake, being careless. She's consciously putting something forward that she has absolutely no idea about, and that is more than just being beyond, out of her depth, to use my lady's, and indeed the expression that was used by Mr Justice Kerr. What she's doing is asserting something that she had no basis to do. Again, I shan't.
That you say is precisely equivalent to knowingly making a false statement.
If not precisely, extremely adjacently close, yes. It arguably is the same because the net effect is the same. Whether you know something is untrue or you have such a reckless disregard as to its truth or not, that is, in our respectful submission, effectively the same, because the whole idea of recklessness is it's akin to intention on that definition. And indeed, that's how it's put at the end of 28. And I know I've spent some time with this case. So can I just remind the court of how the last two sentences of paragraph 28 is put in relation to recklessness. Interestingly, that is described where something represents something as true, which they consciously do not know whether it's true or not. That is consciously, in other words, to the audience, in this case the circuit judge, that is consciously misleading the court, and in the view of Mr Justice Aikenhead, should be considered as contemptuous. And that's our point, really. And we say, respectfully, Mr Justice Aikenhead had it right, and that the decision in Berry Piling was soundly reasoned. Significantly, we don't need to go back. That case is cited without dissent, and indeed the reverse, with approval in the Tinkler and Elliott case that we've already gone to. And just for your note, that's at page 365, paragraph 44. By the way, if it's of assistance, and I don't say this, just want to perhaps save your pen work, we have got written copies of our speaking note, and if that's assistance at the end of the submissions, we're very happy to hand those forward. So we say recklessness as to the truth of a statement made in connection with any proceedings would be sufficient to constitute a contempt of court, and therefore for the grant of permission to bring this claim for contempt of court.
You haven't mentioned KJM Superbike, so
No.
except in passing. Mr Justice Aikenhead doesn't mention it either. I think.
I think he does, my lord. Yes, we are going to go.
What did he say about it? In the case you've just shown us, Berry Piling.
Did my lord want to go to Berry Piling or to the Tinkler case?
No, Berry Piling.
Yes.
I mean, Tinkler you showed us.
Yes.
Paragraph 44, which is which says the judge below in this case gave the following summary of the law, which both counsel before us, the Court of Appeal, have accepted is correct. Now,
I think my lord's right, actually.
Before we get to that, I'm just interested in whether, firstly, did Mr Justice Aikenhead refer to KJM Superbikes? I don't think he did.
That's right.
And secondly, I thought that this court has no right to depart from its previous decisions, and if Tinkler and Elliott, paragraph 44, purports to overrule KJM Superbikes, I think Mr Thomas is going to say they had no business to do it.
Well, my lord, you're undoubtedly right about the first point. I'm going to respectfully submit that when one looks at Tinkler, one sees the authorities all cited. And of course, Tinkler being the Court of Appeal, we're in slightly different terrain than Mr Justice Aikenhead.
Yes.
Can I just, before going away, and I shan't dwell any further, but the top of 247 is the reference that we've been addressing at B in relation to the strong prima facie case requirement being a primary one. So that's where it comes from, that wording. Can I take the court then, because taking my lord's point, to the Tinkler case, which is important in our respectful submission, because not only is it Court of Appeal, but importantly, it deals with all the cases before, and we should, of course, include the KJM case in that. So, returning to paragraph 44 at page 365, you can see there, and I don't think I need to spend long because the court has it, that this deals with, it makes reference to the Edward Neal case we've gone to, it makes reference to Berry Piling at page 365, it talks about the strong prima facie test at top of 366, which cites, amongst other cases, the Kirk and Walton case we've gone to in the Berry Piling. And then when one goes down under, as we've gone to, 5, 6 and 7, 5 deals with Berry Piling. Importantly, the next two, 7 and 8, specifically refer to KJM Superbikes in relation to the public interest point and the issue of prejudice that we've already gone to. And so, importantly, the Court of Appeal is citing with approval the decision in Berry Piling. So although my lord is right that Berry Piling does not deal with KJM, there's nothing to suggest that the court is challenging the decision or the findings of any aspect of the Berry Piling case in Tinkler. So we know from Tinkler, having looked at that at 365 to 366, what the correct legal approach is. And I've gone through paragraphs 23. And it is interesting that paragraph 45 says, right at the bottom of 366, it is not necessary for this court to revisit these authorities. There's really, I'm not suggesting that the court needed to, but there is no suggestion that in any way at all, or in any aspect, or even if anything was obiter, that Berry Piling was not a correct decision. So my lord, right about the absence in relation to KJM, but there's also equally no suggestion anything other than that the court is, accepts the decision in Berry Piling, albeit at then Queen's Bench division level. And we respectfully submit that although Tinkler provides quite a complicated structure for considering permission applications, it broadly aligns with the full code test for criminal prosecution, namely whether the evidence is sufficient for a realistic prospect of conviction, whether it is in the public interest to bring the proceedings. What we say in that context, can I ask the court please to go to the case of Lockett and Minstrel, and that's starting at page 564 of the authorities bundle, towards the end. It's a decision that my lord was part of the court. The case
Sorry,
of Lockett and
which page?
Minstrel starts at page 564. Yes. And the decision of Lady Justice Rose as she then was. And if we look at, importantly, at page 573, there's an interesting, relatively recent, relevant observation in the middle of paragraph 33, which we respect for instance is absolutely apposite. That's at line 6. The damage caused by contempt of court is damage to the administration of justice and the rule of law. So that's, we respectfully submit, when one is looking to the question of proportionality and the public interest, and I do need to go at the conclusion of my submission to what Mr Justice Kerr said about the public interest, that we say it's both proportionate and in the public interest to bring contempt proceedings where that threshold test, in other words, a level of, I don't use to like this word, but triviality, that threshold test has been surmounted. It's in the public interest and proportionate to bring contempt proceedings. As I say, I don't think I need to distract the court, but I'm happy to do so if it assists, to look at the question of Galbraith plus test and inquest. Unless I'm asked to, I shall move on from that observation. But we have tried to look at the different contexts to see what test is the appropriate one. What we then now need to turn on is to specifically to the police involvement and the search warrant application in this context. So we respectfully submit that the court is invited to take into account the following features which arise specifically in the context of search warrant applications. A. Police officers are criminal justice system professionals whom the public can expect to act with honesty and integrity in carrying out their duties as required by their own ethical code. They can reasonably be expected to have either training or seek guidance before making such applications. Secondly, and this was undoubtedly felt by the applicants in the present case, search warrants are by their very nature intrusive. The execution of a search warrant would ordinarily constitute a significant interference with the property owner or occupier's rights under the European Convention on Human Rights, not least Article 8, in addition to causing invariable distress and inconvenience to those affected. Thirdly, the court operates as an important and often the sole safeguard against the arbitrary, improper or unjustified use of such intrusive powers by the police. Fourthly, in carrying out its functions, the court, in this case Mr Justice, His Honour Judge Gratwick, is wholly dependent upon the accuracy and completeness of the information provided to it by the officer who appears before him or her. And if we go to the permission bundle at the document starts at page 85. The declaration is very important. So the applications there in relation to the search warrant, and we shall come back to the detail of particulars in due course, but can I take the court please to page 93, which contains the declaration. It's the middle of the page under subparagraph 6. The Crown Court can punish for contempt of court a person who knowingly makes a false declaration to the court. And to the best of my knowledge and belief, A, this application discloses all the information that is material to what the court must decide, including anything that might reasonably be considered capable of undermining any of the grounds of the application. Those words are important in the context of this case, we respectfully submit, and the content of this application is true. Two observations. One is it has some superficial, at least, similarity with the duties of disclosure in relation to, certainly in a criminal case and arguably in a civil case as well, where you have some sort of duty to consider material undermining the grounds. And importantly, and it's self-evident but important, of course it doesn't say to the best, just simply to the best of my knowledge, it's knowledge and belief. So there is interconnected, but knowledge and belief are significantly both outlined. Returning to the general observations, the hearings of such applications are invariably ex parte. That gives rise, we respectfully submit, to an enhanced need for probity, honesty and candour on behalf of the applicant. Sixthly, the courts, usually rightly, place great trust in what an police officer tells them, relying upon the presumed position of trust the police officer enjoys. All officers making such applications should be aware of this, we say, and the importance of the court being able to rely upon them. And I hesitate to use the analogy of counsel appearing before the court, but it's the same sort of idea that when a question is asked, when information is sought, when a reassurance is sought, one expects the response to be one that recognises the position of trust that the court places in those that are there to serve them, to assist. And police officers, definitely in our respectful submission, should properly be considered to be in that position of trust to the court. And finally, the personal impact on individuals in respect of whom such search warrants are unlawfully obtained can be significant and severe, and can give rise to, as we respectfully submit happened in this case, a legitimate sense of violation. The highest public interest arises in the needs, we say, for the courts to be able to rely upon the integrity of what they are told by public officials, including police officers, in making applications for highly invasive warrants to search and seize. And in that regard, although we will come back to different aspects of Mr Justice Kerr's judgment, I would ask the court just to note what is said at paragraph 36 at page 109 of the core bundle.
Mr. Metzer, a few minutes ago you mentioned that you were using a speaking note and you would be happy to hand in copies later. Seems to me it might well be helpful for us to have the speaking note.
Of course.
Partly because it may save us writing things down, but also because I think as a matter of due process, anything that we see, Mr. Thomas should have a few minutes' notice of, rather than you hand it to us and sit down and he doesn't know what it says.
I wasn't proposing,
so
my lord.
If you are going to hand it in, perhaps you could hand it in now. But if you're not going to hand it in, well, that's fine.
Very happy to, my lord. I wasn't suggesting for a minute my learned friend shouldn't have it.
No.
What I was going to suggest that when I finished his submissions, or at the end of the hearing, we provide it, but we can do it now just as easily.
No, I think if we're going to see it, something handed in on the day, we ought to see it now.
Of course, my lord. I hope that will still be permitted to. I'm making reasonable time
Yes,
if it assists that the court will finish from certainly this morning.
Yes. Thank you very much.
We're going to obviously need to turn to Mr Justice Kerr's judgment, and there are aspects, indeed, although we were unsuccessful before Mr Justice Kerr, there are some interesting aspects. I know the court has looked carefully at this judgment already, but on this point, there is. Can I raise, particularly in the modern era, some concern about what's contained at paragraph 36? If I had been of the view that there was a strong prima facie case of deliberate misleading of the court in more than a trivial way, it's interesting that the question, Mr Justice Kerr appears to be agreeing to a degree that this question of non-trivialness might be the threshold question of strong prima facie. One doesn't know, but it's certainly interesting he says that. I would most likely have followed the same course of the Court of Appeal in KJM Superbikes and granted permission. It is this sentence that, with the greatest of respect, eyebrows are raised on behalf of the applicants. It is difficult to see any public interest in permitting knowingly false evidence to be given to a judge with impunity. We respectfully submit that it is precisely this type of situation. There's a very strong, high public interest, we say, in the courts being able to rely on the integrity of police officers making applications and answering questions from the court before the granting of such a warrant. I think the last, no, it's probably not the last case. I think there's one other case that's of some assistance to the court, hopefully, in relation to the question of granting permission. That's the Aaron Coghlan and Daniel Bailey case. That's to be found starting at page 437. And it's at page 441 section I'd ask the court to look at, starting at paragraph 19. In that case, the court repeated the decision below of Mr Justice Mitting, finding that the test for granting permission to apply for committal proceedings was met, and that applied the KJM case, and you can see that at paragraph 20. And Mr Justice Mitting commented as follows, and this is at paragraph 20. Mr Justice Mitting went on to say the test set out at paragraph 16 of the judgment of Lord Justice Morbick in KJM Superbikes for granting permission to apply for committal proceedings was met. He commented, Mr Bailey was a public official appearing in coercive proceedings against an individual. As Mr Talbot accepts, there was a duty of candour upon him. He had had this opportunity to explain why it was that paragraph 7.1.2 is erroneous in the respect that I have identified and has not taken it. In my judgment, there is a high public interest in ensuring that public officials making statements in these kind of proceedings do so with, as far as is humanly possible, complete accuracy and certainly with no intention to mislead. Although there may well be a complete answer in due course to be provided by Mr Bailey, it is not on the material that I have reviewed evident at the moment. Accordingly, in relation to this ground, I conclude that permission should be granted. And that's quite significant. First of all, it talks about the duty of candour. Secondly, the high public interest in ensuring public officials make statements do so accurately. And interestingly, it seems to contemplate a wider question than just no intention to mislead, because it talks about complete accuracy and certainly with no intention to mislead. In other words, that's the minimum threshold, but accuracy goes beyond intention. And taking really my Lord's point, we're not talking about the ultimate hearing here. So there may well be a complete answer. In other words, the criminal standard test on a full hearing may well not be borne out. The real question is, it's on the material at that stage as to whether there's enough to grant permission. And in that case, it was held there was. And so we respectfully submit that the threshold for the grant of permission in contempt proceedings generally should not be elevated in the context of an application for a search warrant. In other words, the same test should be applied. To the contrary, there's a credible basis, we submit, that the court should be more readily prepared to allow contempt claims to proceed in search warrant matters, given the particularly high positions of trust held by police officers applying for warrants before the court. It's paramount that police officers should not be held or be seen to held to a lower standard or immunised in any way from action where they, as here we say, mislead the court or and thereby obtain warrants unlawfully. And we respectfully submit, concluding on this first question about the permission question, there is no proper foundation for any conclusion that to lower or maintain the test in relation to officers seeking warrants would have a chilling effect or may lead to defensive policing. There's simply nothing in the point, we say, Such suggestions will be little more than speculation, and there's nothing before the court to suggest that, and indeed the relevant bodies who could potentially advance such a case, not before the court. So that's all we say on the permission question. May I move now to submit? Oh, yes, sorry, my lord, quite right. I'm rounding my June. I need to take one paragraph from KJM, which you asked me to do.
Yes.
It's at paragraph 23, page 88, and then I shall move on.
Sorry, could I have that page?
Yes, certainly, my lady. Page 88. Noteworthy, perhaps at 87, I don't think I need to take you to this, but the Court of Appeal held in that matter, paragraph 22, that the judge was wrong to refuse KJM permission to bring proceedings in this case. The important section is paragraph 23, which is important in terms of the public interest. So it's at page 88. The judge's conclusion that proceedings for contempt in this case would be unlikely to promote the integrity of the legal process or respect for it in the future is one which I find difficult to accept. It is true that only prominent examples of the kind that are widely reported in the press can be expected to make an impression on the public at large, but that is to ignore the fact that the pursuit of contempt proceedings in ordinary cases may have a significant effect by drawing the attention of the legal profession and through it that of potential witnesses to the dangers of making false statements. If the courts are seen to treat serious examples of false evidence as of little importance, they run the risk of encouraging witnesses to regard the statement of truth as a mere formality. That is not a matter which the judge appears to have taken into consideration. In my view, the prosecution of proceedings for contempt in the present case would be likely to have a salutary effect in bringing home to those who are involved in claims of this kind, of which there are many, the importance of honesty in making these witness statements and the significance of the statement of truth. So this is not simply a signing form-filling type exercise. This is a serious matter that has to be understood in relation to integrity. That completes my submissions on the first part. I'm happy to move on to submissions on the merits of the appeal, which is the second part of my submissions. So we say, taking us to the merits, applying the test as we suggest it should be applied, reminding the court that it's permission only, we look to the facts of this case. On the legal structure, the granting of warrants involves an important process in the engagement of a safeguarding role of rights by the judge being asked to grant the warrant. If we go to the case of R and Chief Constable of British Transport Police, that's at page 280. The relevant section is at paragraph 45 of the judgment, which is at page 290. The court emphasised that the information provided to the court is the sole basis upon which ultimately the judge will grant the search warrant, and that officers applying the search warrants must, and I'm summarising what's contained there, address the relevant statutory criteria, give full details, and make full and frank disclosure. The court continued to quote the words of Lord Justice Hughes in the case of Stanford International. In effect, a prosecution seeking an ex parte order must put on his defence hat and ask himself what, if he was representing the defendant or a third party with the relevant interest, he will be saying to the judge, and having answered that question, that is precisely what he must tell. And you can see that at D on page 291. This was observed to be a heavy burden, but a vital safeguard. That's the third last line of D at page 291. Stressing this last point, the court held, this is at paragraph 67, which is to be found at page 296. There was a duty on the applicant police officers to ensure that full, complete and frank disclosure was made so that the judge had the fullest possible information in determining whether statutory criteria were satisfied. This included drawing the judge's attention anything which militates against the issue of a warrant, and there's a reference there to the case of Austin and Chief Constable of Wiltshire Police, Mr Justice Ouseley, referring back to the Bow Street case, practice note. So, by way of analogy, of course it's not a police case, but way of analogy, some assistance, if we go to the case of Walton and Kirk, which is to be found starting at page 102. At page 130, page 130, paragraph 120. As with the incapacity for work questionnaire referred to above, this was a claim for a state benefit, and Mrs. Kirk signed the declarations that the statements that she made in making this claim were true. She verified that again in the litigation. Unhappily, for all these reasons, I have concluded that the declaration was knowingly untrue and that this particular amounts to a second proven allegation of contempt of court. And we have gone already to the Coghlan and Daniel Bailey case, which I think we probably just need to return to very briefly. Sorry to jump around. It's at page 437 of the authorities bundle.
Sorry, just before we jump there, can you just remind me which paragraph you were just reading?
120, my lady.
120, thanks very much.
At page 437.
Kirk and Walton was allegation of contempt against a claimant in a personal injury case for grossly exaggerating her symptoms and making false.
That's right. It's not exactly on all fours. It's obviously it's an analogy only, but it stresses the significance of how serious the declaration needs to be considered. But my lord is absolutely right.
Yeah.
So returning to the Coghlan case, it's at 437. And we say that this case serves as a timely reminder that anyone who provides a statement which is ostensibly false may be subject to contempt of court proceedings. In that case, and we can perhaps go to paragraph 19, which I think we went to previously at 441, in granting permission for contempt proceedings, Mr Justice Mitting had held that in the absence of any explanation from the alleged contemnor, it was difficult to understand. You can see that at line 5 of paragraph 19 with the citation of paragraph 6. In the absence of any explanation from Mr Bailey, it is difficult to understand how he could have come to say that having analysed the conveying files, the banker's draft represented funds from an unknown source. The court also noted at the bottom of that citation, the position, therefore, at the moment, there is no explanation of that error, or worse, in paragraph 7.1.2 of the witness statement. Again, noting the reference to at the moment, in other words, on the permission question, not on the ultimate determination. And at paragraph 20, we've really gone through already, I'm reminding the court of the reference to the duty of candour and the high public interest. So the grounds of appeal, the merits of this appeal, we say we have to ask the question, did the learned judge err in refusing permission to apply for committal for contempt? The grounds of appeal, and I can take this quite shortly in summary form, is that the learned judge below, Mr Justice Kerr, failed to have any adequate regard to the Berry piling case when finding that there was not much, in his citation, not much room for reckless falsity of that kind in a case such as this, if indeed the notion is sound at all. Secondly, failing to address the specific wording of the declaration accompanying the warrant application. This is a summary. I'm going to take the court to all 5 observations. 3, failing to find that there was an arguable case, and of course that's the test, that the respondents had misled the court, having found that as he did, the first respondent did not do the necessary research and forensic work that would have exposed the weaknesses in the case, and that the second respondent confirmed the correctness of the information in the warrant application that is now known to be and conceded to be erroneous. Fourthly, speculating as to the honesty of the respondents. And fifthly, failing to take into account the impact the actions of the respondents had on the applicants, the severe interference with their liberty, and the respondents' duty of candour that we've referred to, and full disclosure to which they were subject. I'll deal with the general case, but turning on to the specific ways in which we say the officers misled the court and committed, at least arguably, contempt of court. There were 4 applications that, because we wanted to have the bundle not to have unnecessary pages, we only have the 4th application, the most relevant one, before the court. But for the court record, the applications were dated the 15th of March 2019, the 22nd of March 2019, the 26th of March 2019, and then finally, and we need to go to page 85 of the permission bundle, on the 2nd of April 2019. Those are the 4 applications. On the permission bundle, if we look at page 85, as I think we already have done, the second respondent applied at Chelmsford Crown Court for search warrants on the instruction of the first respondent. So the search warrants related to the applicant's home and business premises at 4 Hadley Business Centre, address 351 London Road in Benfleet, which was connected with the first applicant. By way of history, the first 2 applications were heard by Her Honour Judge Lynch, Queen's Counsel at Chelmsford Crown Court, and they were both granted, although neither was executed. Third application was signed by the second respondent on the 26th of March 2019. It's not clear whether it was ever considered or granted by the court, but was certainly not executed. On the 9th of April 2019, following some amendments, the 4th application, and the relevant one for present purposes, for search and seizure, was granted by His Honour Judge Gratwick, the Honorary Recorder of Chelmsford, at a hearing. The warrant granted that day was executed a week later on the 16th of April 2019, at which time the applicants were also arrested. Later, in August 2019, the criminal investigation was discontinued. Judicial review proceedings were brought in August 19, judicial review proceedings were brought, and by August 2019, during those proceedings to quash the search and seizure warrant, it was conceded by the Chief Constable of Essex Police the following, and we need to go to the permission bundle at 396. Interesting how the document is titled Summary Grounds of Part Concession and Part Resistance of the Second Defendant. And if you go, please, to pages 401 to 402. Although there are concessions contained within paragraph 22, it's paragraph 23 that's of particular relevance in the present submissions. There were failings in the application form and in the assistance that should have been given to the judge at the hearing. You can see that paragraph 23, and we've got citations there, 7 concessions. The application form failed to give an adequate explanation of the market background against which the products being developed by Blue Tractor failed to be evaluated. The application form failed to reveal that no complaint had been made by any person as a victim of fraud. Third, the application form referred to information from Companies House but omitted to mention that there were registers of shareholders consistent with shares having been issued to investors. Fourth, the application form had interposed the word significant typographical error, which suggested that the current balance of the first applicant's bank account was £202 million, which could have been misinterpreted as meaning 200 million. In fact, it was 202,000. Fifthly, the description of material in box 2A of the application form was not identical to that of the draft warrant. In particular, box 2A included any high-valued item, and this was not replicated in the draft warrant. Sixthly, in box 3C, the application form asserted that the investigation may be seriously prejudiced unless immediate access to the material could be secured, but failed to give any cogent explanation as to why this was the case. And seventhly, the second respondent gave inaccurate information also about the offices that had the business centre when reasonable inquiries would have revealed that it was in fact an accountant's office. So now turning to the search and seizure warrants applications, each of those warrants contain the same declaration, and I don't think we need to go back to it for your references at page 93 in the bundle here in relation to that declaration. We say that there is evidence to show that in breach of that declaration, the second respondent failed to disclose all material information to the court and omitted information which the respondents were aware of and which might reasonably have been considered to be capable of undermining any of the grounds of the applications, and reminding the court that's important to be disclosed. The first respondent was the lead officer who directed the process and thereby, we say, connived in and caused the breach of declaration. First respondent oversaw the investigation, had considered the available material, and he made the decision to apply for the warrant. What were the allegations? We can tell from this application, we can see that this is a money laundering investigation under the Proceeds of Crime Act 2002, sections 327 and 329, whereby predicate offence is suspected to be one of fraud in Essex. It's said or claimed in the application that the first appellant's company alleges to have invented an algorithm for the stock market and offered shares to investors with the promise of huge payments. The fact that vast amounts of payments appear to be in cash is indicative, it's said, of money laundering, and it is believed that the companies, Norman, that's the first applicant, is running, are money laundering fronts. These in turn are enablers for organised crime to exist. Enablers are pivotal to the effectiveness of every organised crime group, OCG, and frustrating the terms of POCA, Proceeds of Crime Act. It's believed that this individual has found a way to launder his proceeds of crime in a way that circumnavigates the financial systems and institutions in a manner that enables money and funds to be layered through various purchases and enterprises, of which the tractor companies is one, until they are laundered clean. That's the allegations. The information. The core feature of the suspicion alleged against the applicants was unexplained wealth. The application forms refer to that, and we can see that at page 86 and 88. And they refer to records held by Companies House. And we probably need to just go to Companies House document. I'm going to spend a very short amount of time to show how even a cursory consideration of the Companies House material would have shown what the true position was. So just for your reference, the Companies House is to be found at page 112, starts at page 112. And as I say, I'm going to come back to that. That's in the permission bundle. However, we say, and critically, the applications did not disclose the following. A search of the Companies House website in respect, and there are 5 companies, of all 5 companies, reveals full, up-to-date filing histories in relation to each company, including statutory annual returns, signed accounts, exemptions relating to small businesses, capital statements following an allotment of shares, confirmation statements, and changes of particulars in directors. Secondly, the capital statements and annual returns include full particulars of the allottees of the shares and shareholders. The statements of allotment records record the amounts paid and the numbers of shares allotted on each occasion. Thirdly, the shareholders number many hundreds. For example, Global Financial Solutions Limited has 1,102 shareholders. So I'm going to take you briefly to a couple of documents on that regard. Blue Tractor has 457 shareholders. Blue Tractor Europe has 88 shareholders. The allotments of Global Financial Solutions Limited shares date back to 2001. And the records show the shares are fully paid. Moreover, importantly, there is a share premium in respect to the companies, i.e. amounts have been paid in excess of the nominal value of the shares. For example, Blue Tractor Limited has a share premium of £1,158,584. Global Financial Solutions Limited has such an account of £882,713. These are amounts paid in respect of shares in excess of their nominal value. They are therefore, these funds, £2 million approximately in the companies, entirely consistent with the recorded allotment of shares and payments. Therefore, and as I say, I'm going to come to show you that shortly, the consequence is that taking all the matters together, with the payments into the company bank accounts, the company house records prove conclusively the amounts, dates and identity of the payers of the sums of cash paid in. They also prove the reason for the payments, i.e. payments for the shares allotted, and wholly negate or undermine any allegation of money laundering, specifically the reference, presumably intending to support that allegation, at page 2 of the applications, page 87 of the permission bundle, stating that the balance of £42,000 in the blue tractor account and the turnover of 1.5 million is made up of payments from individuals ranging from £1,000 to £8,000. And as I say, that's at page 87 of the permission bundle. I think it probably will be helpful if I take the court to aspects of the share of the company's house material, which I think will help the court.
So will it? I mean, you're saying that if the officers who were the subject of the contempt application had taken the trouble to look up the companies at Companies House, they would have found legitimate accounts and so on. I mean, the contents of the legitimate accounts don't seem to me to add or subtract from that proposition.
Well, my lord, I'm not going to go to the court. Is not going to be assisted. Of course, I won't go there. Can I say that we say a cursory look at this material would have established that there was no basis whatsoever in relation to fraud. That this was self-evident, clear, and obvious on each and every page of the company's house material. If the court's prepared to accept that on our submission, then I'm not going to take the court there. But I can tell the court, just so you, just for your records perhaps, the full details of shareholders are at pages 151 to 188, and you might find it also instructive to look at pages 134 to 148 of the judgment of the company's house material to show, for example, on 3 pages 137 to 139, we've got 141,000, 208,000, and then 207,000 in those pages, which comes at well over £500,000. And I'm not going to take the court, but the material is clear, self-evident, and fully disclosed. And so, my lord, if that is prepared to be accepted, I hope it will be, then I shan't take the court to it. But those references are there, should the court wish to look at it. My lord, my helpful, my own Julia, says that in that regard, perhaps we can just look to page 210 of the permission bundle, because it's not simply a case that the respondents didn't look at the material, and if they had, they would have immediately realised there's the whole legitimacy of the business. What we have at page 210, and it's at paragraph 8. This is the statement of the first respondent. The court will see under 3, it's clear that the first respondent looked at the company house material, because it says at 3, company inquiries indicating Blue Tractor Europe showed as dormant. Other companies checked were Global Finance Solutions, Blue Tractor UK and Towergate, all of whom submitted accounts which show no turnover. So the material was undoubtedly considered by the first respondent. So it's not a situation that he didn't do the check. He's asserting he did, and that relies upon that.
Somebody did.
I suppose somebody did, yes. he, as officer, one would presume, who orchestrates the investigation, would have relied upon that material.
Is there any dispute about points 1 and 2 in that paragraph?
Sorry. We can probably check that, but as far as I know, 1 and 2 are not challenged. We now need to turn, in our respectful submission, to the algorithm referred to in the application for the warrants. On the 14th of March 2016, Blue Tractor Group and LLC and Blue Tractor ETF Trust filed an application for exemptive relief with the Securities and Exchange Commission in the United States in order to permit registered open-end investment companies that are ETFs, exchange-traded funds, actively managed to operate without being subject to a daily portfolio transparency condition. Whilst working as a consultant at Morgan Stanley, the first applicant encountered the problem of being able to price and hedge a non-transparent, actively managed exchange-traded funds share, which is known in the marketplace as an ETF share. And after 2 years, he managed to solve the problem and filed a patent to protect his ideas as an intellectual property. The court may be asking, what are ETFs? I will explain that in a moment. For now, let's call it a financial product. In 2001, the first applicant set up Global Financial Solutions Limited to exploit the intellectual property contained within a patent of his. Shares were sold in GFS, and all the monies went into GFS, the Global Financial Solutions bank account, to cover the cost of marketing his idea in the United States, paying himself a comparable salary. And in return, these investors were to participate in any future revenue streams. He'd purchased the original GFS shares with his own money and was the sole director. I will come back with an explanation, but according to Wikipedia, not always the best source, but perhaps of assistance in present purposes, an exchange-traded fund is a type of investment fund, an exchange-traded product, i.e. that are traded on stock exchanges. ETFs are similar in many ways to mutual funds, except that they are bought and sold from other owners throughout the day on stock exchanges, whereas mutual funds are bought and sold from the issuer based on their price at the day's end. An ETF holds assets such as stocks, bonds, currencies, futures, contracts, and/or commodities such as gold bars, and generally operate with an arbitrage mechanism designed to keep it trading close to its net asset value, although deviations can occasionally occur. Most ETFs are index funds, that is, they hold the same securities in the same proportion as a certain stock market index or bond market index. The market for a non-transparent actively managed ETF product is enormous, estimated to have potential to be a multi-trillion-dollar business. Amongst the items seized during the execution of the warrant was a court order relating to Towergate Solutions Limited with an attached confidentiality agreement and litigation-related documentation, which is clearly to and from legal practice connected to a piece of litigation conducted here and in America. The first applicant had instituted proceedings for infringement of a trademark algorithm for trading on the American Stock Exchange. This litigation was eventually settled. The American Stock Exchange agreed to pay royalties in the sum of £120,000, plus added interest, to Towergate Solutions for the use of their software in exchange for Towergate assigning all its intellectual property rights to the American stock market. Following that litigation, the first applicant devised a new algorithm called Shielded Alpha, which is the software program referred to in the warrant application. So I'm saying, I know this sounds a bit discursive, but it's important that one understands the context in relation to the warrant application. So the first applicant devised a new algorithm, which is the software program referred to in the warrant application. We say the exemptive relief application, the SEC documents, needed to be carefully reviewed with a reasonably open mind, and then the following text would have been noted. Various aspects of the Shielded Alpha registered mark ETFs are the subject of pending patent applications. Clearly, not only, we say, were trademarks being applied for, but also there were pending patents intended to secure the intellectual property within the algorithm. So, we need to go to the SEC application. That's at page, I don't know if it's in the bundle.
224
Of the,
permission.
yeah. Page 224 of the permission bundle. Sorry, we think we've got the page, giving you the wrong page.
It starts at page 230. Page 234.
Sorry, we think it's 234,
Yeah, 234.
not 224. So there's a typing mistake there. Page 234 of the contempt bundle. It's the top paragraph. As an initial matter, the applicants note that the Securities and Exchange Commission has issued orders on exemptive applications that involve actively managed ETFs, including actively managed ETFs operating the master feeder structure. And then, I don't think I need to read the rest of the paragraph. You can see there's a reference to the shielded alpha that we've gone to. Funds that would allow for efficient trading of shares through substantial portfolio transparency and publication of information, metrics, etc., etc. And importantly, also, for present purposes, at page 246, I think we just checking the page. Actually further along.
It's page 256.
It's we're 10 pages out again. 256. The top of 256. In addition, as described above, applicants believe that in light of the fact the funds will provide the information required by the shielded alpha solutions, arbitrage activity shall ensure that differences between NAV and market prices remain low. And you can see the rest of that paragraph. And importantly, the next paragraph, applicants also believe that the funds will not present any new issues with respect to the exemptions, which allow ETF shares to trade at negotiated prices. And you can see there the rest of that paragraph in relation to what is the applicants believing that buying and selling shares at negotiated prices is appropriate in the public interest, consistent with the protection of investors, the purposes fairly intended by the policy and provisions of the 1940 Act. So in both Europe and in the United States, financial institutions trade in exchange-traded funds, ETFs. For present purposes, proper and full explanation is beyond this submission. But, taking it very briefly, actively managed ETFs are a form of what we call basket of mixed investments. They can consist of commodities, bonds, stocks, and shares, etc., which have a particular value.
Sorry, Mr. Metzer. I don't know about, maybe my ladies are on top of this, but is it really necessary for us to understand this? Because speaking for myself, I'm struggling, and I can't see why the details of how all this works are material to the decision we have to make on permission.
Well, I'll leave it there.
Maybe I'm the slowest child in the class, but
no, it isn't. It is for those who don't know. I absolutely put myself in that and to instruct in this matter. It's not straightforward. Really, what we're saying is it was all transparent, clear, and apparent. But I don't think we need to take it further. We were thinking of drawing an analogy in relation to ingredients for a cake, but I'm going to leave that as well. Simply say this, that the first applicant drew on his knowledge of mathematics and a strong background of this type of trading to develop this algorithm, allowing shares to be traded in an actively managed ETF on an intraday basis, which is the shielded alpha. I'm not going to, just for your note, I'm not going to take you now to the second, in light of my Lord's observations, which I'm sure is agreed by his colleagues, but it's at pages 23 through to 24 of our speaking note, now that the court has it, should that be appropriate. And I'll move on, if I may, to the application and the lawyers. In March 2015, the first applicant instructed Washington attorneys, and there's a citation there, it's at Commission Bundle, pages 383 to 4, to lodge an application to allow his software to be used in the marketplace. He eventually creates Blue Tractor as a financial vehicle to account for and eventually pay back the new investors, given he had to fund it himself, and to fund the expenses of exploiting the intellectual property. And by 2019, legal fees of over $1.2 million have been paid. That's important in terms of the context. By March 2019, the application had been amended no fewer than 6 times. And you can see that if you look at Permission Bundle, page 228. If you look to 228, there are 6 entries near the bottom of the page, and they go backwards in time. So do you see there, the first one is the 28th, that's the second entry from the bottom, 28th of September 2016, and then going up, 1st of February 2017, 31st of July 2017, 17th of January 2018, 11th of April 2018, 23rd of May 2018 are amendments in relation to the application, each filing detailed and substantial, revealing a clearly legitimate business, and had been looked at, which we know, by the first respondent before the decision to search, to seek the search warrants, and we know that from the evidence we've gone to. The first respondent, in his evidence in the judicial review proceedings, claimed that, in his opinion, the purpose of the application made to the SEC, and we can find this at page 213 of the same bundle. At 19.7, page 213. Further open source material did show that there had been applications made to the United States Securities and Exchange Commission. However, this was the extent of the virtual footprint, quite unexpectedly scant for a company of its nature who were promising to deliver such large returns on investor funds. I was of the opinion that the purpose of this was to portray and his quotes, veneer of legitimacy to the enterprise designed to appease investors. As was said helpfully by Mr Justice Kerr in the core bundle at page 108. Just go to that.
Well, it's there in your speaking notes.
It is, maybe. But just so you know, it is helpful to see what Mr Justice Kerr described as the SEC application showing Blue Tractor doing the opposite of what the application had shown, placing itself on record with an internationally respected body with all the powers that need to scrutinise the properties of Blue Tractor's business. That's undoubtedly true and just demonstrated by the evidence. The shareholders and investors are kept informed of everything taking place in America by means of shareholder meetings, regular newsletters, and I think it can't, we've set it out at paragraph 25, and there could be no suggestion of anything not being open, transparent, and informing the shareholders and investors of all possible information. And then we've cited many press releases surrounding the progress of the exemption applications, and those can be found at pages 323, 352 to 358, 362 to 365 of the permission bundle. The respondents knew that no complaint had been made against the first applicant's companies by any shareholder or investor. We say each of the applications failed to bring vital SEC evidence to the attention of the court. This was a fundamental error. The above matters that we've gone through plainly contradicted, undermined, and explained everything in relation to the matters alleged against the first applicant, demonstrating to him to be, we say, and there's no evidence to contradict it, a bona fide business person engaged in the sector of financial technology and having been so engaged for many years. It also, importantly, rendered unlikely any connection or arrangement he was alleged to have had in what's claimed to have been laundering money for an organised crime group and dealing in cars and watches. The warrant contained the following important and erroneous assertion, and that's at page 88 of the permission bundle, which is, I of course accept we have set this out in writing, but I think it's important one sees how the warrant describes it at page 88. It is believed, it's towards the bottom of 88, that the company's Norman, Mr. First Applicant, is running on money laundering fronts. These in turn are enablers for organised crime to exist. Enablers are pivotal to the effectiveness of every ACG and frustrating the terms of POCA. It's believed that this individual has found a way to launder his proceeds of crime in a way that circumnavigates the financial systems and institutions in a manner that enables money and funds to be layered through various purchases and enterprises, of which the tractor company is one, until they are laundered clean. That is simply wrong and dangerously wrong. At the hearing on the 9th of April 2019, very properly, the judge at Chelmsford Crown Court, the circuit judge, asked the second respondent about the nature of the Hadley business park premises, and that's a point that my lady asked me about earlier. If we go to page 107 of the same bundle, we have the proceedings which took place before His Honour Judge Gratwick, when an application is made by the second respondent. The judge was concerned that the premises may be some sort of serviced office block and that multiple businesses could be effectively occupying the same area, and he sought to eliminate the possibility of other businesses being affected when the warrant was executed. We can see that D.C. Wilkinson has been sworn to give evidence. She states on oath, both in direct response to questions by the circuit judge and of her own volition, really from page 109, we can see towards the bottom, Judge Gratwick asked, can you just tell me a little bit about 4 Hadley Business Centre? And then if we turn the page to 110, we have this. The judge says at the top, is it a business centre where lots of companies all over the country have their registered address? D.C. Wilkinson, no, it's a purpose-built block of business offices. Yes, if you like, an all-individual office within that big block. So number 4, Judge asked questions about, is it him and him alone? D.C. Wilkinson, it's just him and that company. There's no other people. And then a bit below, Judge asks, is it a room? It's a room. Officer says, they're pretty much like this, rooms with computers and desks, and that's how they operate. I follow. So if, for example, I haven't a clue, but I had a business and I wanted to have that as my registered business office, I could apply there, and in return, presumably for paying rent, there would be a designated room that was attributable to my business and I could use. D.C. Wilkinson, that's correct, but obviously only one person could have control of that room at any one time. Exactly, so there's no danger. The concern I have is of material being seized. Oh, related to some other company, then no, that's relating. And then at the top, that wouldn't happen, Your Honour, 111. So, of her own volition, in response to direct questions, she's setting out that the material of the application was true, the best knowledge and belief. The premises are a purpose-built block. Number 4 is a room with computers and desks. There were no other people in there at all. Only one person could have control of that room at any one time, and there was no danger that material could be seized relating to some other company. In fact...
Also say we've not actually been in it.
Sorry, my lady.
She also says in the bit that you skipped over, I'm not suggesting you deliberately skipped over it, but she did say we've not actually been in it.
Yes.
Yeah.
She did.
So she's describing something she hasn't seen.
Yes. Yes, but asserting things as a matter of fact. Well, you're quite right. I could have cited that. I was looking for the material discrepancies. Absolutely.
The search warrant application was, of course, in respect of 2 sets of premises. Mr. Norman's home,
yes,
Roper's Farm, and this 4 Hadley Business Centre.
That's right.
And the main burden of what is said in the search warrant application, some of which has either been highlighted or redacted so we can't see it, but what we can see, the main burden of it seems to be that we are informed that there is huge amounts of cash at Mr. Norman's home, and that he hasn't paid any taxes to HMRC for 2008. The judge didn't ask any questions about those aspects, but he asked about the business centre.
That's right.
Yes.
My Lord, what we know, we don't necessarily need to go there, but we can, just for your reference, at pages 277 and 278 of the Commission Bundle, the address at 4 Hadley Business Centre is the address of Masons, a firm of chartered accountants,
Yes.
which displayed in large letters, and the information was plainly wrong. We say there can be no reasonable basis.
Before you move on, and
Yes,
let's
my lady.
just deal with what really is quite a short transcript, just taking up my Lord's point about
Yes.
the fact that the judge didn't ask about anything other than, as it were, the other premises. He begins, doesn't he, by asking the officer if the information contained, the material contained in the information in the application, first of all, was correct, and then to the best of her knowledge, and he queries belief. Yes?
Indeed.
Yes. So that goes to everything that's in the application, and then he just takes it up on one point.
Yes, and importantly, my lady, draws rightly my respectful submission. Of course, there'd been a previous hearing, which we don't have the transcript of, where, and important for that is, first of all, the judge says a little bit lower, unless I'm mistaken, having reread the application, that doesn't change from the materials before me on the previous occasion, but also, relevantly perhaps to the observation that's been made by my Lord, at the very beginning, Judge Gratwick says, now, Miss Wilkinson, we've been through this before. So it may be, we don't know, that the question of the home premises had already been addressed at the earlier application. We simply don't know. But it really looks like by this occasion, the judge is troubled about the business premises. But what had happened previously, she says there's no material change. And there may have been questions, we simply don't know, as to whether he was asked questions initially about the home address. So we say there can be no reasonable basis for the incorrect information as set out to have been provided. At no stage, even in the acknowledgement of service in these proceedings, was there an explicable error on behalf of the second respondent. It's not been suggested that the information was second-hand, that there was any doubt about it, or as is clear from, we say, from the transcript, was any reservation expressed or any request made for time to confirm the details. I don't know, I wasn't there myself, Your Honour, I will check that point. We obviously need to satisfy ourselves, for example, about the nature of the business premises. And we say, therefore, the irresistible inference is that the aforementioned statements were false and known by the second respondent to be false when she made them. And undoubtedly, the learned judge did take that information as being direct, reliable, and honest. We therefore submit, reminding the court of the test, that there's a strong prima facie case of contempt on the evidence. We say there is clear and powerful evidence which cannot be seriously or credibly challenged, that first, in relation to the Blue Tractor SEC applications, there's been a number of legitimate applications made for exemptive relief granted. Applications constitute evidence of legitimate and valuable business endeavours by the applicants, and the Crown Court were not told at all about these applications. And in relation to the Company's House material, taking it shortly, Company House records indicated significant documentation showing legitimate trading by the appellants, including up-to-date filing histories, significant level of shareholders, records showing shares fully paid up, total amounts of approximately £2 million. And then so far as the applications referred to Company's House records, they were not included in the Crown Court's consideration. The Court wasn't provided, therefore, as it should have been, with all material information. And at the hearing of the application, those questions asked by the Circuit Judge of the second respondent in relation to the registered business address were wrong. It is trite law, of course, that the respondents have a duty of good faith and of candour, and required to provide the judge with all material information material to the applications, including anything which might reasonably be considered capable of undermining any of the grounds of the application. A cursory reference to any of this material would have been sufficient in our respectful submission, capable of undermining any of the grounds. We know, because it was conceded in the judicial review claim, that material information was omitted, and we don't need to go back to it again, from the applications for warrants, and that the second respondent has given inaccurate information, just for your note, again, page 401 of the permission bundle, and that these facts are at odds with her declaration that was signed. The undertaking that she provided in the application, we say, was a deliberate act, and the warrant application form contains a warning reiterating the importance of requiring for all material information to be provided. On any view, and of course this is the test, it calls for an answer. We do not say at this stage that there's no possible explanation, that the second respondent could have a genuine explanation, but we simply don't know. But in a respectful submission, calls for an answer. And although the respondent says, and we accept, that they don't have to do this, it's noteworthy, we say, on the respondent's acknowledgement of service, and you can find that at page 21 of the permission bundle, that the acknowledgement of service doesn't deny the accuracy of the applicant's case, and more particularly dispute that the respondents omitted to provide the information alleged to have been omitted, that it was material, and that the second respondent provided the answers to His Honour Judge Gratwick in the transcript which were false. Nor does it set out any claim that either respondent was misled by any third party. There's a reference, of course, to another officer in the submissions below, and referable in the judgment of Justice Kerr. There's nothing about misled by any third party or other police, including a police officer, was negligent, not that such an assertion would be sufficient to absolve the respondents, we say, or otherwise fell into honest error. And we invite the court to find that if any action for contempt is reasonably pursued, it should be allowed to proceed. There simply are no other avenues to appropriately address the mischief in the present matter, other possibly in the private prosecution. This is not a judicial review where alternative remedies act as a bar to review. And we respectfully submit that the learned judge was wrong to have refused the application for permission. And we turn briefly, and I'm going to do it briefly because I know the court has it very much in mind, Mr Justice Kerr's judgment. We ask the court to note, and I'm not going to spend long on it, but note, first of all, at page 106 of the core bundle, this is a submission my learned friend made at 15.6, a concession at the bottom of 106. The transcript of the hearing shows that the second defendant did not knowingly give false statements, evidence of on oath, he says. She clearly lacked experience and made incorrect statements, but would not have had incentive to do so knowingly. So there's that concession there. And importantly, we respectfully submit, and we'd ask the court to remind itself at paragraphs what's said about the first defendant. There's a reference there to D.I. Dibble, as I mentioned, but nothing contained with the acknowledgement of service to say that he's the responsible officer. Paragraph 20, first defendant had little understanding of the way in which Blue Tractor conducted his business. 21, he didn't do the necessary research and forensic work which would have exposed the weaknesses in the case that the claimants were money launderers and using their private property for that purpose. He did not research the company's house documents. He certainly referred to them, but didn't refer to them. A really poor error in relation to the bank balance being 202,000, not 202 million. Didn't verify the nature of the business premises. Evidence that he did not properly brief his subordinate, the second defendant, in these words, is very strong. And he did not follow up with any investigation of the communications, contenting himself with the suggestion that he intended to lead a veneer of respectability. Paragraph 24, it is troubling that he did not require the second defendant to tell the judge about communications between Blue Tractor companies and the SEC. Particularly important for the judge to be told about the SEC application because the case advanced by Essex Police was that Blue Tractor was trying to operate outside the conventional financial system without proper paperwork, and that the SEC application showed Blue Tractor doing the opposite. We've gone to paragraph 25. And as far as the second defendant is concerned, I asked the court to note what's contained, already been referred to by my lady at 29. The judge finding she was out of her depth professionally, should not have been asked to take on the responsibility for which she was ill-equipped. And so there is much within the judgment, although of course we challenge the ultimate findings that we rely upon to set out the history and the findings in relation to the role of both the first and the second respondent. We don't, of course, accept at paragraph 30 that the confirmation of erroneous matters consistent with honest mistake as was nefarious intent to deceive. The judge says far-fetched, a form of very likely. Of course, we don't need to go necessarily as far as that. What is clear at paragraph 35, as the judge found, the warrant should not have been applied for or granted. Then the question is whether there's a strong prima facie case. We've made our submissions in that regard. And we say, in so finding, when the judge found at paragraph 35 that there's not much room for reckless falsity of the kind such that this, if indeed the notion is sound at all, he failed to have regard to the Berry piling decision. And again, we go back to that, which we needn't recite again. We respectfully submit, finally, and just as I'm concluding, that the learned judge failed to address the specific wording of the declaration which warned the respondents that contempt of court would be committed if undermining evidence is not put forward. That undertaking sets this type of contempt apart from the cases we've looked at, the insurance personal injury cases. Respondents rely upon as an extra duty, we say, upon police officers in applications made on an ex-parte basis to be proactive during the intelligence gathering phase, and the second respondent endorsed the declaration. We also say the learned judge found that the first respondent, and we've seen that, did not do the necessary research, and indeed the second respondent confirmed the correctness of the information in the warrant application that we now know is untrue. We therefore submit as a clearly arguable case requiring an answer from the respondents and that permission should have been granted. We respectfully submit that the learned judge appeared, we assume unintentionally, to criticise the circuit judge for not asking more probing questions, which he believed would have exposed the second respondent to be an honest person. That's at paragraphs 32 to 34. Of course, we take the observation made by my lady, but we simply don't know what happened on the previous occasion. He considered the circuit judge might have asked, what checks have you carried out? And he might well have answered none at all. And these, we might have answered personally, none, but I understand this has all been checked. Whilst his line of question may have been helpful in relation to understanding whether in fact a claim for contempt against a second respondent had merit, there's nothing in the dialogue to be seen in the evidence in this case, and indeed was an exercise in speculation, and we simply don't know what could have flowed. And respectfully submitted, the judge fell into error in reaching a decision based on speculation as to the honesty of the respondents, because he deals at paragraph 30 with just saying that, in his view, the erroneous matters is more likely to have been consistent with honest mistake as opposed to nefarious intent. The evidence, we say, doesn't demonstrate any equivocation, caveat, or suggestion that the matters referred to are not within her direct knowledge, and we've gone to the transcript. Even if it is possible for her to persuade a court at a full contempt hearing that she fell into error and misunderstood information provided by another officer, we say the evidence is sufficient to call for an answer, referring in parentheses to paragraph 20 of the Aaron Copeland case that we've gone to. As a further example of impermissible and in fact erroneous speculation, what we heard advanced, and we've seen at 15.6, a surprising submission that the second defendant responded to Detective Constable lacked experience, and you can see that at page, going back, it's 15.6. And we've dealt with really the point in relation to the issue about how the second respondent was out of her depth. There was no evidential foundation for making a finding that she shouldn't have been asked to take on a responsibility for which she was ill-equipped. So we say Finally, and this really is the last point that I want to make, can we go once more and finally to a different passage in Berry Piling, paragraph 31, page 244. Paragraph 31 is to be found at page 247. It goes almost without saying that after over 15 years of their deployment, that statements of truth incorporated in witness statements or in pleadings are and must be regarded as important. People who sign or authorise the signing of such statements of truth must appreciate that there is a real possibility that the court might act on the basis that they are true and that the opposing party might well have regard to them also. People who sign them, knowing that the contents of the attested document are untrue, must also appreciate that they may face contempt proceedings and possibly independent criminal proceedings. In the case against the second respondent, we say it was even more acute. She'd taken the oath and adopted the application, gave further evidence to the circuit judge. We also, finally, respectfully submit, the learned judge appeared to overlook the impact the actions of the police had on the applicants, a search warrant being a severe interference with individual liberty and should only be taken after mature consideration of the facts. The officers making the application being under the duty of full disclosure of relevant matters, and I don't think I need to take you to it. The case of Chatwani is support for that proposition, and the relevant paragraphs, it's at page 421, paragraphs 106, sub 3 and sub 4. So I'm adding that, that's not in the speaking note, but if you want to go there, there's support in relation to that proposition. Even in the unlikely eventuality, the respondents might be able to persuade a court that they were themselves misled by others, even though that's not contained in the acknowledgement of service, or that it was a gross failure rather than deliberate misleading, which has not so far been advanced, we know. They were nonetheless deliberate acts where the warrant application form contains a warning, reiterating the importance of all matters, material matters, and information being provided, and we respectfully submit clearly calls for an answer constituting, we say, a strong prima facie case. Public interest in favour of this contempt of court plain proceeding, of taking the view to what's contained at paragraph 36 of the judgment. We respectfully disagree with that. There's a strong public interest in the court being able to rely upon the integrity of police officers before a court making applications for invasive warrants, and in the circumstances, we respectfully invite the court to set aside the decision and grant permission to bring contempt proceedings. Unless I can assist the court any further.
Admirable timing. Thank you very much, Mr. Metz. We're very grateful to you. Mr. Dos Santos.
Thank you.
2 o'clock.
Oh,